Good morning, everyone. I'd like to open the proceedings by acknowledging the Ngunnawal people, who are the traditional custodians of this land, and to pay my respect to their elders, both past and present. I'd like to welcome you all to this forum. We've held several forums now about this time of year, and it's good to have so many people to this one, which is largely a capacity crowd. To briefly introduce the Australian Digital Alliance to you. The Australian Digital Alliance is the peak cross-sector body which advocates for flexible copyright reform that balances the interests of creators alongside the public interest in fair access to information and education. We, in putting together the program for today, hope we have represented a cross-section of people with a variety of interests in copyright as users, creators, owners and so on. And we hope that creates a productive outcome, one that's valuable for further thinking about copyright. Clearly our focus this year is on the Australian Law Reform Commission work on copyright and the digital economy, and we made a major response to the first discussion issues paper, and we'll also be focusing on that this year too. We've also been engaged in a wide range of other copyright issues, the Trans-Pacific Partnership Agreement negotiations, WIPO discussions about exceptions for the visually impaired and libraries and archives. We commissioned a discussion paper from Policy Australia on the application of Section 200AB by Australian cultural institutions, and we worked with Lateral Economics on their economic research into flexible exceptions. We've also rebranded ourselves in the last year, as you can see, and you can see that too by going to our website, which has got a great deal more content and a new brand and look. So that's the ADA. The ADA is very pleased to involve you in this forum. Just a couple of housekeeping things. There's a Twitter hashtag, which is #ADA2013. There are copies of the program and speaker bios that are available in hard copy and on the ADA website. You can click through to links for works of speakers and so on. And recordings of all discussions and presentations will be made available online by about the middle of next week. We have two keynote speakers today. New Zealand District Court Judge David Harvey and Associate Professor Matthew Sagg. I'm very pleased to be able to introduce Judge Harvey. We'll first of all hear from Judge Harvey, and then panellists will come up on stage for our first panel, which will be chaired by Tom Cochrane. District Court Judge David Harvey has literally written the book on internet law in New Zealand, and is considered one of the foremost experts on internet law and copyright-related issues in the New Zealand judiciary. He's a sought-after commentator and keynote speaker on the impacts of the internet on copyright, law and other legal areas, as well as attempts to monitor and govern it, and he's written extensively in the field of law and technology. Judge Harvey was chair of the Copyright Tribunal in New Zealand from 2002 to 2007, and he's a consultant editor with Butterworths, as well as a member of the editorial board of Butterworths Technology Law Forum. He lectures at the Faculty of Law in the University of Auckland and teaches law and information technology. We are delighted to welcome Judge Harvey to present our first keynote. Thank you.
Where did we put it? Excuse me, where's our techie person? We had this on this laptop here, and now it seems to have vanished. Yeah. there it is. It was hidden behind the behind the PowerPoint. Thank you very much for that very kind introduction. It's always difficult working out just exactly what role I occupy. I'm a lawyer by training. I'm a judge by present occupation, and that's only temporary, even although it's been for the last 25 years. And I'm an academic, probably by inclination. I enjoy technology, so lurking down in the depths of the subconscious there is a geek. And also I'm an historian because my doctorate was in legal history, even although it was about a technology. And we'll come to some of that in a little while. I want to thank the ADA for their very kind invitation to speak. This, of course, casts huge obligations to satisfy the audience, and I trust that some of the ideas that I'll be putting forward, and I put them forward more from an academic perspective than from a judicial one. In fact, some might say that my remarks are going to be quite injudicious, will be of assistance to you in considering approaches to copyright. The theme that I want to put across is that we are in a digital paradigm. We are in a digital paradigm that materially and significantly changes the way in which we approach information, the way in which we deal with information, our expectations of information, and I suggest to you that that in fact has a huge impact upon our behaviours and upon the values that underlie our behaviours and upon many of the assumptions that we have about copyright and copyright thinking. My suggestion to you is that much of our thinking about copyright is based upon an old paradigm. And we really need to start thinking about what copyright is going to look like in our new paradigm and whether or not the assumptions upon which our current copyright regime is based have any validity at all. If the circle C means anything, it means contentious, because copyright law and copyright as a theory has been contentious from day one. The standard arguments, of course, are that content owners don't think they've got enough protection and they want more. And consumers think that content owners have too much protection, and really there should be a lot more flexibility. To give you an example of the way in which content owners think, in New Zealand, as you know, we have just instituted a 3 strikes regime as far as file sharing is concerned. This is a special enforcement remedy for copyright owners to deal with a special type of infringement that is developed within the digital paradigm. No longer do copyright owners have to consider going to a traditional court, the district court or the high court, to seek a remedy. They have a special remedy for file sharing. So they don't have to pay the enormous filing fees to get proceedings into court. They don't have to pay for expensive silks to argue the case. This straightforward, fast-track procedure is available for $25 per complaint. And now they want that fee lowered even less. So that perhaps gives you an idea of content owners thinking about extending the range. In fact, they say that $2.50 is probably a better complaint fee. Of course, the consumers say, well, we should be able to do a bit more sharing, and we should be able to deal with the information in the way that we want to, and I'll develop that theme in a little while. But there is a fundamental truth about copyright, and that is that it is the child of the printing press. And it developed within the introduction of the printing press within the first few hundred years after the printing press came to England. But there are some myths about copyright as well, and one of the myths is that it's a property right. And I would suggest to you that it's anything but. It is, in fact, about control of technology. And that is what copyright is all about. It's what it's been about since the first copyright statute. It's what it's about even now. Another myth about copyright is that it originated as part of a stationers' company licensing regime in the 16th and 17th century. And you always get copyright people saying, oh yeah, look, let's go back to proto-copyright. It was that stationers' company licensing regime. And my argument is that it was not. Who were the stationers' company? They were a craft guild. They were involved within the industry of making and writing and binding and illustrating and selling books. They brought all of these different disciplines that were involved in book production together under the one umbrella of the stationers' company. And like any craft guild, they were interested in protecting the interests of their members. They didn't like people coming in from the outside, people who weren't members of the guild getting involved in book production. So it was kind of like trade unionism. We don't want anybody working in the area who's not a member of our organisation. And they went to considerable steps to exclude from the pursuit of the craft those who were not members of the guild. The stationers became an incorporated company in 1557. They received a royal charter at that time, and this enhanced the control of the industry. It also put in place the special licensing regime that you hear talked about within the context of copyright, but this had nothing to do with copyright or any idea of protection of intellectual property. Members of the stationers' company received a license from the company to print a certain book. The reason for this was that the stationers' company was able to ensure that only members of the company were involved in printing activities, because the printing press, of course, has been with us by 1557 for over 100 years, and in England for 75 years. So they were only interested in making sure that only stationers' company people were involved in the printing of books. The Charter of Incorporation actually gave them powers of search and seizure. And the reason for this was not censorship, not content control, as everybody seems to think, but it enabled the stationers' company people to go after those who weren't members of the company, who weren't members of the guild, who were involved in the illicit or pirate printing of books. It had nothing to do with copyright. It had everything to do with the stationers' company control and supervision and protection and monopoly over the new technology. Alongside of the stationers' company licensing regime were royal patents. We find this word might be familiar in a slightly different context. A patent in those days was a royal authorization to get involved in the printing of certain titles. So printers could receive a royal patent, for example, to print the prayer book, a valuable patent in the days when attending church was compulsory. Patents were often infringed. The common law patent holder, who was entitled to print all of the books of the common law, was a printer by the name of Richard Tittell. He wanted to print an abridgment of the statutes of England. The King's printer, who had the patent to print the statutes, said, no, you can't do that. That's my patent. That's covered by my patent. No, says Tittell, I'm not printing statutes, I'm just printing an abridgment, head to head, the sort of argument that we sometimes hear today. And so they went to the Court of Star Chamber, the prerogative court, to resolve the dispute. And there were a number of infringements of patents and arguments about patents of a similar nature that ended up in the Royal Prerogative Court of the Star Chamber. In fact, there were so many printing disputes that Star Chamber was unable to deal with them one by one, and in 1587 and in 1634 issued sets of decrees about the way in which the printing trade was going to operate, a sort of umbrella type of decision to deal with a whole lot of cases. Now, these decrees had nothing to do with authors' rights. They had nothing to do with censorship. They were all about protection of the publisher, because the stationers' company was sitting in the background basically saying, this is what we would like to see, this is the model that we would like to have for the printing trade. So, for example, in the decrees that came out, there were restrictions placed on the number of printers. who could carry apprentices, restrictions on the number of printing presses that they could have, restrictions on the number of people who could make the lead types, the founds that printers used. It was all about industry control. It was all about limiting participation in the industry. It was all about the closed shop that the stationers wanted to maintain. And this all came to an end when Star Chamber came to an end and we had the English Civil War. But to give you an example of an approach to copyright, we've got to remember that at this time there was a tremendous amount of material. In fact, the majority of the material that was available for readers was in manuscript. You had a vast range of poetry that was in manuscript. And printing was seen as the way in which this information, this content could be disseminated. Printing was an answer to those ungentle hoarders up of treasure, said Tittel in the preface to his book on poetry. Publication, he said, is beneficial to the studious of English eloquence. And that he said in his book Tittel's Miscellany, a collection of poems of Lord Henry Howard, Earl of Surrey. Printing at the time, in fact, was seen as an inroad to this close market of manuscript publishing. It gave everybody an opportunity to see the content. It was an act of sharing that which was hoarded, a meme I would suggest that still has some validity today, but a different technology. Following upon the Civil War, where there were difficulties with the licensing regime in England was restored with the Licensing Act of 1662. And as a result of this legislation, there were controls on content by way of censorship, and there were also controls on the industry. And once again, the focus of the printing industry, the focus of the book trade, the focus for the new technology was upon the stationers' company. The stationers, once again, were in charge of enforcement. And the 1662 Act was rolled over and renewed every couple of years until 1694, when the Licensing Act lapsed. And for 15 years, there was a period of what you could call press freedom, where anybody could get involved in printing. There wasn't any more of the stationers' control. The stationers wanted to make sure, however, that they still maintained control of the printing trade. And so there was a tremendous amount of pressure that they put upon the government and upon the authorities to do this. But what it resulted, of course, was something completely different. And it was the Statute of Anne 1710. If you have a look at the language of the statute, you'll find that it is very, very limited as far as the focus is concerned. It only has to do with printed works. Doesn't have anything to say about manuscript. You want to copy manuscripts? Go for your life. After all, it was the only way that manuscripts could circulate. So the Statute of Anne actually reflected the coexistence of the printing technology on the one hand and the manuscript culture, if I can call it that, on the other. But the important thing about the Statute of Anne was it was about, again, control of the technology, not about this strange concept of property right. And I would suggest to you that it has been about control of the technology ever since. Every time there has been a new technology, there has been the necessity to revisit copyright law to encompass that new technology. Copyright rules are technologically neutral? Give me a break. That cannot be true. Look at it. You've got performance rights. You've got broadcasting rights. You've got communication rights. You've got all sorts of different rights that reflect new technologies. Copyright is about technology and distribution of content control, and it has been all the time. What has happened, however, is that the power balance has shifted, because making LP records, broadcasting radio and TV, publishing books requires a large amount of capital investment. So the technology has been in control of monolithic organisations. Distribution of copyright material has been a one-to-many. But now the situation has changed. During the development of copyright, of course, we've had a number of cases, Miller and Taylor, for example, where the idea was put forth that there was this underlying interest in copyright that was protected by the common law, and I'll come back to Miller and Taylor shortly. Then Donaldson and Beckett said, no, the statute rules, and there's contention about that decision. Interesting thing about that was that none of the plaintiffs in those cases were authors. None of them, in fact, were the creators of content. It was all about the publishers. It was all about the control of the distribution, control of the technology. And it all changed when the photocopier came along, because that shifted the power balance. All of a sudden, I, an individual, can put a book in a photocopier and copy off a couple of pages, or all 250, if I didn't want to be too worried about things. And then following that, of course, we have another shift in the power balance to digital technologies. The distribution of content is no longer one-to-many, but many-to-many. The power balance has shifted from monolithic publishing organisations to individuals. And just as it was in the days of the stationers' company, so it is today. The response of copyright owners has been shut down the technology, control the technology. The Betamax case, shut down video cassette recorders. These are copyright infringement tools. Yeah, oh no, we won't worry about those potential markets that we might have for DVDs and remarketing our catalogues of movies on video cassette. We just want to shut the technology down. MP3 players, Recording Industry Association of America and Diamond Multimedia. No, we don't want MP3s, get rid of them. What would have happened to iTunes? And then, of course, in England, CBS Songs and Amstrad, the double-reel cassette tape recorder, let's get rid of that. These are all about infringement. Let's shut down the technology. Let's stop progress? Nah, we wouldn't want to do that. Now, of course, as far as copyright owners are concerned, there's another meme that has developed. Because in the digital world, we can actually manage to control the content. The answer to the machine, said Charles Clarke, lies in the machine. And so we have the development of technological protection measures and digital rights management. And this begins to be a way in which copyright owners can lock up their content. And so you have the development of what Justice Kirby called in Sonny and Stevens the concept of para-copyright. Those sort of overlays on basic copyright theory, once again, that are protected by law. Technological protection measures and their circumvention is prohibited by law. You have the development of para-copyright. Now, the thing about the technological protection measures and digital rights management is that this overlay gives content owners an opportunity to control the distribution and use of their content. And in the case of Sonny and Edmonds in England, it was held that the terms and conditions of the sale of copyright product governed the arrangements between buyer and seller. And it basically meant that by contract, a copyright owner could set up their own copyright regime that often would go way beyond what was provided by the statute. And so you have the possibility of locking up content for far longer than the copyright term, the possibility of absolutely preventing fair use by prohibiting the circumvention of access control measures that might enable a person to copy a part of the content for the purposes of review or something like that. And what you have with copyright by contract is, in fact, the dream that was put forth in Miller and Taylor that could suddenly become a reality. A universal, completely extensive copyright regime that was not governed by statute at all. But on the other side of this particular debate, we have another aphorism that comes from Marshall McLuhan, and which deals with the way in which we behave and the way in which we deal with information and our expectations of information. And the aphorism is that first we shape our tools, and then our tools shape us. our behaviours about information change. Our expectations of information change. The digital natives, those people who were born, say, after 1985 or 1990, have totally different information expectations than we do, or than I do. My first port of call, if I have a query, well, it used to be, is an encyclopedia or a dictionary. Digital natives will go straight to Google or Wikipedia. They can't understand why you would want to have a telephone that only does one thing, enables communication, talking with other people. What? A telephone that does only one thing? You mean you can't do other stuff like text and Twitter and all the rest of it? They don't understand. They're wired differently. Their entire overview of the world of information, their entire view of the world, shaped by their ability to communicate, is entirely different. And within these information sharing activities that they have is the world of social media. So social media are just one slice of a huge information pie that digital natives are dealing with. Social media, the varieties of social media, the way in which people communicate, the friends that they make that they've never seen, are a new way of thinking, a new way of dealing with information enabled by new communications technology. Now what happens with the digital native is that they find that copyright law interferes with this global view of information and information sharing, which they see as part and parcel of life in the 21st century. For example, the regionalisation of content obstructs their information now expectations. On a website called Throng, they published the following. We had published the official full episode of Banshee, an excellent television program starring an excellent, of course, New Zealand star, Anthony Starr, in the leading role, from the YouTube. But the powers that be have swung the axe and enforced that God-forsaken geo-blocking technology. While non-cable subscribers can still view the episode in the US for free, it is now available via iSky to Sky subscribers. The cry of the digital native confronted by regionalisation. Digital natives find it difficult to understand why they have to pay for a product that copyright owners won't let them purchase or won't let them access. You see, I can't subscribe to Hulu because I live in the wrong part of the world. I can't download content from Amazon Songs because I live in the wrong part of the world. I can't access some of the content from iTunes because I live in the wrong part of the world. But hey, we live in a global economy, people. Globalization of content and e-commerce have made the commercial world a world without boundaries, yet content owners seem to have overlooked that rather small problem. You see, digital natives are actually prepared to pay the money. I've got my credit card out. I'm ready to pay. You don't want my money? Well, I want the content. So the answer to the machine lies in the machine. I guess I'm going to have to share it. There's that outfit, what's it called? BitTorrent or something like that, I think. I don't know. Digital natives are kind of like Jim Morrison. Jim said that in 1968. It's as relevant now as it was then. Technologies changes. Now, if you want to think about it, think about the levels that media actually work on. The first level is the content layer. This is the one that we're all familiar with. We actually don't think too much about it. Media allow us to communicate and access media content, and it's all about delivery technologies and so on and so forth. And that's the focus of copyright and content controllers these days. But beneath that is another layer. It is that associated set of protocols, those social and cultural practices, the values that we have about information that have grown up around the technology. You see, my first port of call in the morning is not the newspaper, it's Twitter. That's where I get my primary source of information. Then I go to the other stuff. That's part of my social and cultural practices that have grown up around the technology. The delivery system is just the machine. It is that second level, how you're utilising the information, what your expectations of the information are that generate and dictate different behaviours and different values. And when we go beneath that delivery system, that content layer, and we look at the properties of new information technologies, we're looking at what shape and form the basis and the changes for our behaviour and social and cultural practices. Now, the qualities of digital technologies drive this. And these qualities are paradigmatically different from anything that we have experienced before. And they deal with and drive the way in which we approach information. Hence, Marshall McLuhan's rather opaque statement that the medium is the message.
Whether it's an electric light or radio or telephone or TV, each of these media creates a new environment. It creates a new situation for human association and human perception. Any medium at all creates a new pattern, a new atmosphere, a new environment of human perception, which works upon the whole man. It works upon the whole society. That is the effect of the medium, has that total pervasive effect. That is the message, the social change that is brought about. The content of the medium is never the message, because the content is always the old medium.
So what are some of these qualities? I've just identified a few of them. There are probably dozens more. Persistence of information. Information is always there. A reality of our current environment as far as digital technologies is concerned is continuing disruptive change. Nothing stays still anymore. We don't have that consistency that we're used to in terms of introduction of new technologies, which come along and then things flatten off for a while, and then something else happens. Change is happening day by day, week by week, and year by year. Information is dynamic in that, as well as being available, it is constantly changing. It's being added to, it's being modified. And furthermore, new technologies have the power of dissociative enablement that allow people to say things to other people that they'd never say to their face, that allow the criminal the cyber criminal to do cyber crimes of fraud and so on and so forth, identity theft, that they'd never even contemplate if they had to come face to face with the victim. Dissociative enablement, or alternatively disinhibition, if you want to call it something else. Most of what happens on the internet doesn't require anybody's permission or sign-off. It doesn't require the government to say, yes, you can do this. Look at what Facebook's done. Look at what Twitter's done. Look at Amazon. Look at all of these things that have been built on the backbone of the internet. Permissionless innovation is a reality. And this permissionless innovation means that that continuing disruptive change is going to continue to happen, and our expectations of information are going to change. Information's always available. We can participate with information as a result of Web 2 and Web 3. Blogs, comments, the developing news story. The first opportunity that the silent majority has got to really no longer remain silent. Talk about democratization of information. At last, it's here. Thomas Jefferson would have loved it. Information is searchable. You can Google it if you can't remember what it was all about. I couldn't remember a case just the other day, so I Googled it, and there it was. It was the first hit. It was a matter in Canada. I should have gone to Canley, shouldn't I? And then, of course, it's instantly retrievable, because once I found it, it's there. I can drag it down. I can read it. And if I'm a juror, I can read that news report about the guy's arrest, the guy that I'm currently trying. I can read about that, and the information is as fresh as the day that I first read it 18 months ago. And so we have the problem of the Googling juror, and I've written about that in another place. So where does copyright fit within this new paradigm? Well, I would suggest to you it was a system of rules derived from the print paradigm that do have very little relevance in the digital paradigm. And the thing that I'm concerned about, as far as being a lawyer and a judge and a legal academic is concerned, is the credibility of the law. Because the law loses credibility if it actually doesn't accord with the underlying values of the community. It's all about the consent of the governed, if you want to put it in a blunt way. And of course, if you have a set of rules that run counter to community values and accepted values, you have an oppression and a totalitarian state, and none of us want that. So what I'm suggesting to you, at least within this field of copyright, is that we find another principled basis for approaching copyright and the protection of intellectual property. And the starting point is to go back to one of those fundamental aspects of copyright, which is that it attracts when the idea is expressed. Copyright and expression are inextricably linked. And what I'd like to do is focus on this concept of expression and draw your attention to Article 19 of the International Covenant on Civil and Political Rights, which protects the right to receive and impart information, to receive information and to impart information. And of course, it explicitly protects the media of expression. It actually looks ahead. It isn't stuck in 1954. It looks ahead to new media of expression and new ways that people might have of expressing themselves. So maybe we should start looking at a rights-based approach based on Article 19. And this isn't new. A few years ago, Frank LaRue, the Special Rapporteur on Human Rights to the United Nations, considered whether or not internet access should be a human right, qualifying for protection under Article 19. And within the context of file sharing regimes and disconnection for file sharing, he mounted an argument that this could well interfere with the Article 19 right to exchange information, freedom of expression. Recently, a German court ruled people have the right to claim compensation from service providers if internet access is discontinued because they consider the internet is an essential way of life. Finland and Sweden have a right to internet access as part of their law. And in the recent case of Ashby Donald in France, dealing with Article 10 of the European Convention, the European Court of Human Rights considered that a conviction based upon copyright infringement could be regarded as an interference with the right of freedom of expression and information. Now, in that particular case, the domestic rule triumphed. But the important thing is that the European Court of Human Rights articulated an information and freedom of expression involvement with copyright that cannot be overlooked. So how would it look if we were to have a copyright regime that's based upon Article 19 and have Article 19 as the umbrella? Now, the first thing would be that copyright should not be seen as a property right, whether actual or inchoate. We've got to get rid of that. The second thing is that the copyright owner's rights are not absolute. The starting point is not the copyright statute. The starting point is Article 19. So copyright should be seen as an exception. This is new. An exception to copyright. It generally works the other way. But no, copyright should be seen as an exception to the wider right to receive and impart information guaranteed by Article 19. Given that copyright doesn't accrue until the act of expression, then that brings in and keys in Article 19 in my submission. Now, if you are going to interfere with that Article 19 right, if you're a copyright owner, and I use the term copyright owner, or perhaps content owner might be better. If you're a content owner, interference with Article 19 right requires you to justify that interference. It doesn't just happen upon expression, it requires justification. And once you've justified that interference, any restriction to the general right to receive and impart information that may accrue to the content owner can be permitted to the extent that it is necessary to meet the copyright owner's justification or the content owner's justification, and it must be proportionate to the level of interference. So concepts such as fair use and the term of protection and the remedies and their extent all fall within these tests of necessity and proportionality rather than being seen as exceptions to the copyright owner's right, which is the current way of looking at things. So thus, if you have a look at things like access controls, which have no copying implications, they could not be justified as an interference with Article 19 rights. Copyright or copying that is necessary for a technology to operate could not be considered as a justifiable interference. Format shifting, for example, of any medium to any medium could not be justified as an interference in that, or given that, a royalty has been paid at the point of sale where the item has been legitimately acquired. Now this framework, I would suggest to you, is all against this backdrop of the right to receive and impart information. And I would suggest to you gives you a balanced approach to information and expression that recognises that ideas are the building blocks for new ideas and allows for the better development of the intellectual and knowledge society of which we are a part. But there's got to be a recognition by content owners that they've got to change because our expectations, and particularly the digital native expectations of information, have already changed and are already way ahead of the current law. The new technologies change our approaches. And rather than shut down new technologies or dismiss these ideas out of hand, perhaps content owners could see them as a new opportunity rather than as a threat. Let's not shut down the new technology or the new approach. Let's think about it and work out if we can in fact live within this and make it an economic reality. Because at the moment, I would suggest to you that copyright is something of a one-way street. And it can't really continue to be that with traffic heading only one way and that direction of travel dictated by content owners. Thank you very much for your attention.
Thank you very much, Judge Harvey. There'll be time for a couple of questions to Judge Harvey just before we ask the panellists to come to the table up here. But before that, could I please ask anyone who's standing, who's joining the audience today, there are some seats down here. We do have a fully subscribed day today, but we do have room for those who are standing to sit. So please do that. So, before I introduce the panel, do I have a couple of questions for Judge Harvey? Yes, please.
Marcus Wigger, Electronic Frontiers Australia. Very persuasive presentation, but of course the persistence of vision raises other types of problems. The privacy, individual rights, and national security issues are all at variance to that philosophy, as they are with the current systems. And it would be most valuable if you were to give some of those perspectives that you clearly thought about the new reframing of copyright.
I think that we've got to recognise that there are entirely different visions of things like, for example, privacy. One of the things that I continually say to myself as I look in the mirror and my hair starts going even greyer than it is at the moment is I should get out of the way, because I'm not a digital native. I might be a geek, but I'm not a digital native. I still speak with the accent of radio and television. I still speak with the accent of the analog world and with the print world. And I'm wired differently from the digital native, so why should I impose my values upon a generation that really has absolutely no connection with them whatsoever? You see, I have a particular view of privacy. Heaven knows I'm in the public eye enough. I'd like to be able to get out of it from time to time. The fact that this is being live streamed is an interesting challenge. But digital natives have a different view of privacy. For many of them, it doesn't matter. Now, who are the people who are saying, well, of course it matters? They're my generation, who value that particular type of privacy. Digital natives are quite happy to stick their stuff up on Facebook or tweet about, you know, how many gallons of beer they consumed the night before or something of that nature. The attitude towards private information and the importance of privacy is quite different. And I think that's part and parcel of a technology-driven behavioural meme. I can't say that I've gone too deeply into government, and I should probably stay away from that because you really don't want to hear what I think. But given that I subscribe to the views primarily of Thomas Jefferson, I like Enlightenment philosophy. That might give you an idea of where I come from.
One more?
Graham.
David, your suggestion of using Article 19 of the ICCPR as a starting point is certainly fascinating from the point of view of values. But as a matter of practical copyright law and international law, how do you get around the various straitjackets of the Berne Convention? Have you explored...
When was the Berne Convention? 18 something or other. Yeah, I think that answers the question, does it? It's gone. It's past its use by date.
As a matter of values.
Yeah.
But as a matter of the legal constraints that history imposes, have you looked at the extent to which it can be done as a matter of international law?
As a matter of international law, and the way that things are currently framed with Berne and WIPO and TRIPS and whatever framework is going to be with us with TPP, yes, I entirely agree. So I guess my particular vision has an aspect of the revolution about it. I find Berne interesting because a three-stage test, for example, for fair use, seems to me to be a little bit difficult to work out in a time when we have entirely different technologies that are roaming around that challenge some of the technologies that were present with Berne. I acknowledge that there are other international instruments that protect authors' rights and explicitly say that, the Convention on Economic Rights, for example. But what I am trying to introduce is perhaps a new way of looking at copyright keyed with the right to freedom of expression and freedom of information. Yes, it is revolutionary, and it probably won't fly when I consider the areas of opposition that could come in on this and the way in which these conventions are entrenched. But I think that what we've got to do is start to realise that there are other aspects and other values that are coming in. And you can't have a law that doesn't accord with community values. Otherwise, as I've said, it doesn't have the respect of the community and it becomes oppressive. And I think we've got to consider that. Thank you. Thank you for the question, Graham.